People get divorced every day. 50, 60% of the population, 40%, who knows? But it's a big number. Let me disclaim this. I am not a family law professional. I am not a tax advisor. I'm not an accountant. I'm a realtor. I do see when people come to lease a property or buy a property, somebody runs their credit and the lender or landlord is like, we got a problem. So what do?
I can't fix the past, but I can tell you how to set yourself up for a better future.
In the Arizona revised statutes, there is a statute that says if you need money for your litigation, you can take it. Here's where it runs afoul. I'm talking about ARS 25-315, and specifically it's subsection E. It reads, in a proceeding or dissolution of marriage for legal separation, annulment, or for maintenance or support, or following dissolution of the marriage by a court that lacked personal jurisdiction over the absent spouse, either party, this is the operative part, either party may move for an order for equal possession of the liquid assets of marital property, temporary maintenance or temporary support of a child, natural or adopted, common to the parties entitled to support. The court shall provide for an order for equal possession of the liquid assets of the marital property that existed as of the date of the petition for dissolution or legal separation or annulment was served, unless the court finds that there is good cause not to divide those assets. The court's division of liquid assets held by financial institutions does not invalidate applicable law or any provision of an account agreement that assesses penalties against the account holder for premature or unscheduled withdrawals of account funds. The motion shall be accompanied by an affidavit setting forth the factual basis for the motion and the amounts requested, and, if appropriate, the liquid assets of the parties. An order for equal possession of the liquid assets of the marital property does not prejudice any final division of the marital community. This subsection does not eliminate the application of preliminary injunction. I'm going to break this down for you. If someone needs money and there's cash somewhere or liquid assets, someone can go, hey, court, I need cash. Bad. Can you hook me up, please? I'm going to attest to you in an affidavit. This is the assets. I need it. Can you please grant it? And I'm going to tell you right now, they say yes. They say yes a lot. I'm not going to answer why they say yes. They just do. From a real estate perspective, liquid assets means you have a bank statement that has the person's name, address to show where they are. It has a date like January 1st through January 31st, a month, recent, like in the last couple of months, because cash goes. Especially if you're getting divorced, cash just goes. You want to see that they have these funds, it's clear, and it's on the letterhead of the bank. If I'm a seller's agent and someone's like, yeah, I got cash, I want to buy a house. And I go, okay, show me your proof of funds, your liquid assets to pay for this. If they don't have a statement, I'm going, okay, well then call your bank. Get it on letterhead. I want to see a name, a date. I want to see all this stuff, because if something goes south, my seller's going to sue me because I didn't do my job. The court doesn't have the same obligations that I, as a realtor, do. Loyalty, fiduciary, accounting, all these things that we have to get done to protect our clients. You don't get that in family court. So it's up to you. Make sure that if this is presented, you have seen the assets, you're aware of them. If it's something that's disclosed for the first time right then and there, you got a very big problem. That's one piece of it. Next possibility, if it's not liquid assets, let's just say it's home equity. We had some crazy appreciation in the last 5-6 years. So a homeowner that's been sitting on their house 5, 10, 15 years or longer, they got a lot of equity. People say, well, I need that equity. I need it for this divorce to pay my attorney's fees. Full stop.
Do you remember the couple from my example in part 1?
Party A makes $50,000 a year. They've got $21,000 of credit card. They've got $20,000 of auto debt. They have separate debt. Party A has $2,000. Party B has $15,000. You add all of those up. Court says, okay, we're going to cut that in half. Party A has now inherited $29,000 of debt, and they make $50,000 a year. Party A's debt to income ratio is 58%. Lenders be like, nope.
Yeah, life wasn't looking so good for Party A.
When you use equity from a home equity line of credit, the calculation on interest payments that you make are the same as credit card.
In part 1, Party A got the shaft just for getting half the community debt. Imagine Party B comes along, gets equal possession of the equity line, creates more debt, and reduces their home equity. If Party A doesn't already have a post-divorce home, you want to place your bet on how hard it's going to be to get one now?
If one of the spouses goes, I need this cash, and the court goes, yep, go ahead. They may even enter an order saying whoever gets the debt must be responsible for the payment of the principal and the interest. If you have a spouse that doesn't pay regular community expenses, where you live, your utilities, your carpet, whatever your expenses are, if they just decide they're not paying and then they do this, good luck with that. If you don't understand what I'm saying, stop. This is not for you. If someone proposes it, kill it as fast as you can. I know how to calculate that interest, but you know who doesn't? The parties that's suggesting it, the attorneys, the court. And if they don't get it right, whatever the debt is, it's split in half. Whoever's not requesting it, the other side, they get half of it, even though they don't get any benefit. Because remember, they're using it to pay for attorney's fees or whatever it is that they say they need.
You may have to get the mortgage payments from them. If they don't pay and you can't pay, even if your bank agrees to forbearance so you avoid foreclosure, meaning losing all your equity, the unpaid amounts accrue. If your divorce drags, the new debt eats your equity.
Be really careful. It's on the person not requesting this to know what the hell is being proposed and what is the risk. Whoever puts forth the affidavit, it's supposed to be true, but people lie. If you're in a contentious divorce, expect it to be the de facto. So if you now have a party that's liquidating assets that are not liquid and there's a penalty, when they request for equal possession, and we'll go back to the word equal, let me get into the semantics here. You share it equally. Each person gets half the asset and half of the debt. Because the divorce is not done. This is during the divorce. If you don't make it equal, now you got to go back and calculate what is the difference between then and the date that your decree is final. The value at that point in time versus the date that it's final. The difference in taxes. What is the difference in all of it? And if you can't answer that question, no one does. I say just say no. Courts like to have good reasons for things, even if they don't freaking get it themselves. Go ask a loan officer, go ask a tax professional, go ask somebody who's on top of your finances. What does it do to you? And if you don't like the answer, get whatever the reason is in writing and send that to the court.
Still have questions? Give me a call. Let's chat.